I know this question is about Section 8, and Nadav, during your presentation, you did cover a lot on this, but please tell us, how is it that we can't decline a Section 8 tenant? And do they pay the same market rents by combining Section 8 benefits with additional pays from renters? One, I guess I'm assuming, is can I decline a Section 8 tenant? Yeah. The answer is no. And then do they pay the same market rate? So I'm assuming if it's $2,500, Section 8 covers $1,500 of it, and then the tenant covers the $500 themselves. What if they don't pay that $500?
You can evict a tenant for non-payment of rent if they are paying less than what they owe. The notice to pay rent or quit needs to demand a minimum amount. So for example, for a one-bedroom unit, the notice needs to demand just over $2,000. So if the tenant owes you $500 and you're either in LA City or in the unincorporated areas, you can't evict them until they owe you the $2,000 and change.
I have a tenant who moved in as a father and son. I found out later that the mother lives there too. This has been a long time. I have asked the father and son, and they say she's just visiting, but my other tenants have said she's living there. I have talked to her too, and she said she lives there too. There is no manager at the building. I want to charge an extra person fee on the lease. My management company gave them notice for application and they just ignore me. What can I do?
If it's a violation of a lease provision, you can potentially serve a notice to perform or quit, demanding that the additional occupant either applies and gets approved or vacates the premises. Usually if it's a mother, father, and son, they're not going to move out. So you need to make sure that it cannot be viewed that you unreasonably withheld consent to allow the mother to live with the family. If you extend the application and they just simply ignore you, then you've done what you need to do, and if you want to take an aggressive approach and file an eviction, you can do that. Regarding rent increases for additional occupants, it's highly regulated between different cities. So it will depend on if it's subject to rent control, if it's what city it is, and but technically you can do that if you follow the process.
What options does a landlord have if a tenant is a hoarder inside their unit? Can you give them a 3-day notice to correct this?
Okay, so hoarding is a disability in California, and I'm not trying to make fun of a disability, but this is just another example of how California over-regulates and oversteps, even when it comes to these types of situations. It's not a world-acknowledged disability. It's something in California. It is going to affect another tenant, and just because, or other tenants in the property, and just because it's a disability doesn't mean that you cannot do anything about it. It just means that because you are dealing with a disabled individual, you are expected to conduct yourself in a little higher standard of care. So instead of serving the tenant with a notice, formal notice to clean the place and stop being a hoarder, you'll send them a letter basically saying we acknowledge that hoarding may be a disability and that you may be entitled to certain rights. Therefore, instead of serving you with a notice, we are giving you an opportunity to come into compliance with the lease, and here's what we're willing to do to help you do this. You have, for example, 30 days to comply. Because it's a disability and you don't just, there's no button that you press and the person is a hoarder and then you press it and he's no longer a hoarder. It's a person who lives like that will continue to live like that. So in many situations, the tenant doesn't come into compliance after you send them that demand letter, and then you're free to serve them with a notice to cure or quit and file an eviction against them. And I recommend not allowing a hoarding situation to develop, because like ma'am said, it can impact other tenants, it can impact the property, and it's a snowball effect.
How to prove marijuana smoking in unit as a violation?
Have tenants who are impacted by the smell and the smoke email you, telling you that there's smoke emanating from a certain unit and traveling into their unit. The more complaints you have, the more individuals that can complain about it, the stronger your case is. It's obviously not going to be very easy to prove that someone is smoking marijuana because you need to have personal knowledge of what they've smoked, and usually they're not going to smoke it in front of you and show you exactly what they're smoking. They're going to smoke inside the unit, and you're going to smell it outside. So how do you know that they smoked marijuana? How do you know that it's them smoking? But at the end of the day, if it's a non-smoking building and tenants are complaining, and you want to preserve the building as a non-smoking community, then sometimes you need to take an aggressive approach, even if you don't have the strongest case, and serve a notice and potentially file an eviction and see how far you can take it. When somebody is Section 8, there's regulation as to if you can even run their credit. The Section 8 payment is considered income for the purpose of income qualification. So when you want to see if somebody is making enough money, if the rent is $1,000 a month and Section 8 will pay you $900, the tenant's responsibility is just for $100. That's the number that you need to factor, not the whole $1,000.
Can a tenant deny a rent increase by claiming habitability issues until said issues are corrected? Tenant claims the kitchen cabinets are worn out and need to be replaced.
It's not that there's a law that says tenant can challenge rent increase if the cabinet is not, fixed or something. It's just that how this is going to play out is you're going to increase the rent, the tenant is going to have a rent increase, and then if the tenant doesn't pay rent, you need to serve them with a notice to pay rent or quit, right? And if they don't pay after you serve that notice, what do? Pay attorney's fees, right? Which everybody here doesn't like. And then when you file an eviction for non-payment of rent, the tenant has the option. I don't know if anybody looked at an answer that is filed. It has around 500 different defenses. It takes hours to read and understand. A lot of them are not applicable, but one of them is habitability, conditions that require repair, landlord's failure to repair, and then it's going to need to be litigated. So my recommendation would be to do what you need to do to fix the issue, and at the same time also give a rent increase, but don't just neglect that.